Welcome everyone. Just bear with me. As always, I've just got to do some YouTube back office stuff here. There's that. And then, oh no. Yeah, cool. Right, yeah, welcome everyone. Hope your week's been all right. Usual stuff. This is not legal advice, so we're just trying to be helpful. And secondly, please don't share personal data in the chat. I'm putting in block capitals this week to see if that makes a difference. Oh, wait a minute, what's going on here? It's just retracted that message. Let's try that again. I want to pin it. Pin message, that should do it. So yeah, cool. Yeah. So basically when you ask questions, don't just ask, you can ask the question about your own situation, but just ask the question as a what if. So rather than saying I've been in temporary accommodation for 8 weeks, what should I do? Just ask the question, what if someone was in temporary accommodation for 8 weeks, what should they do? You get the same answer, but you don't have to basically share your personal stuff on the internet, and not just your own personal stuff, but your kids' personal stuff and all that sort of thing. So that's the theory there. That's all the blurb, isn't it? So yeah, no Will tonight, just me, Shannon, and Karis. So any gossip at all? I've literally been like all over the place this week. So I have only just looked at, I hadn't even looked at properly the local government social care ombudsman's decisions this week, and there weren't any last week. So I don't know if there's any interesting stuff there. I have been preparing for a video on whether councils can take your kids off you if you're homeless, and I found some really interesting cases in it. So I'm going to do that video fairly soon. So just some really good principles about. If I was well prepared, I'd probably bring it up right now, because there's a whole bit of a judgment which is talking about how councils have like this. If they've got a duty to do something, they have to do it. There's absolutely no wriggle room. It doesn't matter if they've not got any money or anything like that. So it just kind of says it really well. But I don't know if you guys have got any gossip that's come up this week. Oh yeah, I've got another bit actually. But yeah, go on, Shannon.
Well, so I've been on annual leave this week, so I have not read into it because I have tried to ignore all things homelessness this week, which is really bad. I do care. But I believe the supported housing consultation has come out this week. I did eagerly check my emails earlier today. And yeah, I saw an email about that coming out. So if you've been in supported accommodation, if you work in supported accommodation, if you just have an opinion on it, I'd really highly recommend reading through the consultation. I haven't yet, so I don't know what it's specifically asking for, but normally they're quite simple with how they lay things out, and they normally have like a set of questions at the end. You don't have to answer every question either, so you can sort of like write your own personal experience, whatever you might want to do, and submit it via email. And they all get read regardless of how you submit it. But yeah, I don't know. I normally know a bit more about it, but I have tried to sort of like let my head free a little bit from the sector this week.
Yeah, so I was going to mention that actually. So I think we should do a specific live stream, because I had looked through the questions and I didn't see all the questions, but the questions were kind of like limited. They're kind of their way, there was laid out in a way which kind of limits kind of actually saying what you really think about the sector. So, but it's really important bit of work, because one of the things, and Shannon, you know more than I do, but my understanding is basically there's going to be this set of standards for supported accommodation, and effectively, if a supported accommodation provider does not meet these standards, then it's impossible to be found intentionally homeless from that accommodation. That's my understanding. So it's really important. Actually, it could affect a lot of people, as well as some other bits and pieces it will do as well. So yes, I think we'll get our heads together at some point and basically just plan in a session to do that. I think it's quite a long deadline. I think it's like maybe April deadline or something.
So they haven't recruited for the supported housing advisory panel yet. So I imagine they sort of want the consultation to run, be finished sort of when they're hiring those people. I
Yeah.
think just on the intentionality and stuff, I think I can't remember the top of my head, but you might have to have complained first, which will be really, really interesting because, as we all know, the power imbalances within supported accommodation often means people can't complain. And so it'd be really interesting to see if the standards reflect that. Because like in my head, there almost needs to be like some sort of, I know there's whistleblowing law, like a national complaints policy for supported accommodation clients, and then that is like LinkedIn complaints, whistleblowing sort of standards thing and almost included there. Because otherwise we could have problems with the intentionality aspect if people haven't complained. But I guess, do you think like case law will be quite quick once the standards come out? How often does a change in law? How often? So change in law happens, and
Yeah.
how is like a case law sort of thing that we can get our teeth into?
I would have thought you're looking at like a year at least, like minimum, because you're rarely going to see county court judgments. You're only going to see Court of Appeal or Supreme Court, and I doubt that's going to happen anytime soon. So I think it's going to take a little while to start seeing that. Plus the fact, I mean, we know, I think the reason there aren't case law judgments about things like verification of rough sleepers is the people who are rough sleeping are just not in a position to challenge it. So I think it's that kind of imbalance really. So I don't know, but yeah,
It'll be
but
interesting because I think a lot of supported housing providers are pooing themselves currently. And because it's not just like the support standards, it's like the physical accommodation standards that they are now going to be responsible for, and the licensing will be going through the local authority. So the local authority, the same way with like taxi drivers, they have to be like held accountable and stuff, which will be something that a lot of these exempt supported accommodations haven't been previously. So I think a lot of them are trying to make changes in like anticipation of the standards coming in.
and local authorities will not. They're fairly motivated to actually uphold standards because unregistered providers cost them money, whereas like a registered provider, they get reimbursed for all the housing benefits from central government. For unregistered providers, they don't. So they're a drain on local authority resources. So I think there might be some interest in kind of actually enforcing those kind of standards. So yeah, Karis, you got anything at all? Any news or anything like that this week?
No, sorry, pretty boring.
That's all right. That's all right. There's actually only two questions that come in through the week, guys. So we don't have to kind of rush as much as we normally do, unless those come in the chat. You're right, Stella. So let's get to it. Again, if you find this stuff useful, give it a like. If you haven't subscribed already, give it a subscribe because you'll get notifications of these videos. But if I just get our little virtual flip chart up and running. So the first question is, there's literally two questions, one of which wasn't anonymized. So we'll do that last. And there were quite a few questions that came through the week where literally I've done a video exactly about that thing. So I've just basically just pointed them towards the question, towards the video. That's a better way of doing it. But here's the first question, unless I am much mistaken. Oh, what I'm doing. Hold on. I'm getting there. There we go. Cool. So yeah, question one. Oh, yeah. So considering the stress and trauma some people go through, the councils and housing officers, if somebody finds a private accommodation they can manage and take it, can they make a formal complaint after the homeless application is closed? If they're not homeless any longer, would they be covered by legal aid if they need a solicitor's help formalising a complaint? The situation is very complex and many laws have been broken by the council. The council unlawful actions not trying to resolve homelessness but making it worse have caused extreme distress. People shouldn't go through this kind of abuse. The housing officer and councils inflict on them. The abuse of power is disgusting. So I think, yeah, we would probably concur with your conclusions there. But answering the question, if you're in that situation, you're actually in a really good position to complain because you don't have to worry now about annoying the council. You can annoy them as much as you want to. So basically you can't get legal aid for this sort of thing. Legal aid is kind of the remit of legal aid is kind of focusing on the court process and kind of challenging bad decisions, challenging kind of gatekeeping in real time, whereas complaints are things which happen afterwards and effectively, although a solicitor would kind of know the answer to your questions, probably they won't get paid for it. And housing lawyers are not quite as rich and as affluent as you might imagine, given the way it's all structured. So you may find that actually a solicitor won't help at all. However, if you raise a complaint through the complaints process, use ChatGPT or whatever to actually write it for you if you find that easier. But you just need to, essentially, as long as you as long as you flag up the things that went wrong, and they could range from the housing officer was really rude to they didn't take any action to prevent homelessness or whatever it might be. Just kind of keep it in a numbered sort of list like that. Run it through the complaints policy. The first stage complaint will almost never be upheld. So be prepared for the fact the first stage complaint will just try to essentially wriggle out of it and just try and kind of poo-poo it. second stage complaint might be a bit more useful, but then when you get through to the ombudsman, essentially with the ombudsman, you don't have to like know the law. They know the law. So if you're raising the kind of areas that they want to investigate, they will then investigate for you. And they're pretty good, they're not perfect, and they probably side with the council more than I would like to see in situations where there's a bit of doubt, but they would potentially be very good at that run that process. That it takes months, because often it takes months even to get through the complaints process in the council because they just delay stuff. So, but yeah, once you get to the ombudsman, you can, as long as you're kind of pointing them in the right direction, they'll do a pretty good job of it. Karis, I don't know if you have anything to add to that.
Oh, sorry, I was just gonna. I think you did mention it, the scope of legal aid. So,
Yeah.
although there's that, they've broken the law and they haven't applied the law correctly, what people can access in housing law is completely, it's covered by People Only Lawyers Act for people in homelessness cases and certain types of possession, and for certain things it's called within scope for legal aid. So although they've broken the law, you having access to a lawyer that will be able to challenge that is not always there. So legal aid only covers certain things, and it doesn't cover writing complaints for you or like compensation for certain things. So you would have to do it predominantly yourself,
Yeah.
for complaints and challenging what they have done. But it, like you said, you're in the right position to do it.
Yeah. I mean, I guess one of the reasons why there isn't kind of more systemic changes, the fact that legal aid doesn't kind of cover that sort of work. So lawyers will kind of win the argument and then move on to the next case, rather than being in a position to actually go and take on councils the kind of the wider issues.
Yeah. So
So
even on disrepairs and things like that, where people have to complain firstly. So with the new law that's coming in, there's AWAB's law for disrepair, but they already have a disrepair protocol, but there's compensation for that. That does not even covered by legal aid. It has to be to force the landlord to do the repairs. So though people have, oh, my property has damp or it needs this repairing, we're going to get loads of money. It's not structured like that. So it's kind of that different view, distorted view of what legal aid actually covers for people getting the help they need. And it should cover more than it does. That's why there's a shortage of lawyers now, and why people are in such problems, because it doesn't cover enough.
yeah. Yeah, so I think in a situation like the question is talking about here, it would be probably a case of being on your own, unless you can get very lucky with a kind of local organisation that does help with that. Sadly, a lot of charities won't dare challenge the council because they're too busy sucking up to them for funding. So yeah, but I've seen people get good outcomes. I mean I'm not able to share details. Someone who contacted me not too long ago basically had got three separate compensation payments, like two from the housing ombudsman and one from the local government and social care ombudsman, about the same situation themselves, where they'd basically just gone through it themselves. They kind of done a bit of reading around it, but they weren't experts, but they'd kind of got some good outcomes there. So it certainly can be done. I've also seen cases which would clearly the council had acted unlawfully, and yet it wasn't upheld because of some little detail here and there. So it can be quite disheartening. But I think generally speaking, you've got a good chance of getting a fair outcome from it. Shannon?
Yeah, I was just going to add, perhaps after the complaint process is done, and obviously, talked about like that might take for a year potentially by the time it maybe needs to go to LGO and everything else. But it's potentially worth taking to your local housing committee. Now, technically, I don't think you're allowed to speak about individual cases in a housing committee, as we found out recently. But there is nothing stopping you from talking about the systemic failures that you have experienced within your local authority, and bringing up maybe issues of training, issues of, the behaviour you saw, whatever it might be, and asking questions in the housing committee about that instead, and potentially utilising the freedom of information requests to maybe evidence some of that. So it's not just your word, which obviously completely believe, but do you know what I mean? So you've got a bit more like maybe statistics about how many complaints have been made and upheld in the last year, whatever whatever you've experienced. Their training program, for example. We've had quite a bit of success locally doing that way as well.
Yeah, cool. I've just realised I was sharing the wrong screen there. So the second question I'm going to come back to at the end because it's not anonymised. I'm going to get into the live chat now. So first question from the live chat is, does a PHP need to be signed? Can it be negotiated after it was just sent by the housing officer regarding personal needs? So as far as I know, there's nothing in the law that says it has to be signed, although I'm sure some councils may do that. I don't know. It's probably good practice. But what they should definitely do is send it to you. I can't really imagine, I can't see a good reason why that would not be sent to you in an email. And then if you see things which are wrong with it, as in, literally the officer's just got something wrong, then you can kind of get back to them and correct it. If there's things in there which you don't agree with, there's only kind of limited amount of you can actually do about it at that point. So you can't challenge the reasonable steps that you're supposed to take. It's really weird. But yeah, so you can challenge the reasonable steps the council is supposed to take, but you can't challenge the reasonable steps that you're supposed to take. So if it's asking you to do something unreasonable, the only way you can challenge it is basically wait to be told that you've been uncooperative, and then challenge it then, which is a really stupid and unhelpful way the way the system works. But yeah, so doesn't need to be signed. Can it be negotiated after? It's just so in one sense, PHPs are supposed to be dynamic documents. They're like, I sound like such an idiot saying this, a living document. So kind of something which, as things change, as things develop in the course of the prevention and relief duties, they are regularly updated. I've even seen some councils have like guidance to staff saying like they've got to be reviewed every 2 weeks or whatever anyway. Whether that actually happens or not, I don't know. No, that itself is not set out in the law. But yeah, as soon as something changes, you can basically just email the council and just say, look, this has changed. My PHP needs updating. Can you get to it basically? So I think that, yeah, that would be my answer to it. I don't know if, Shannon or Karis, you got anything more to say about that one?
Well, I just want to be a bit, probably a bit thick, but actually I'm trying to be overly clever, I think, and it's not working for me. But so you've got the right to rectification under data protection law. Now,
Yep.
obviously, you could utilize that if, say, like basic facts were wrong, right? Like your address or your name or date of birth or whatever. And hopefully, you wouldn't have to go down that route, but that is an option for people. But just in terms of actually, like, what you're saying about when they put down what your actions are, and that's non-negotiable. Well, actually, could you use your right to rectify that information and say it's not appropriate because of, like, I can't go into support accommodation because it's not suitable in X, Y, and Z. So I want to retract. I want to rectify that information under data protection. I don't know if I'm just grasping
Yeah.
at straws here or whatever, but
No, so I think yeah, where it's like a material fact. So say the PHP has got the number of children you've got wrong. Like say it's got, because what often happens is you get the PHP which has been done for someone else and it just gets like badly copy and pasted into yours. So you might say, you've got 2 children, therefore you need this type of accommodation, and you say, well, no, I've not got any children, so it's obviously going to change the PHP. So if they refuse to change it just by asking nicely, yeah, you could. You could effectively complain to the kind of data protection officer from the council and kind of do it that way. My opinion of PHPs is so low that I'm not sure if it's worth the effort. But yeah, no, you're right. You're right, Shannon, in that you can do it that way. I think it's just probably. I would say just kind of sending an email to the council saying this detail is wrong. Can you correct it, please? Would probably be enough to
for
cover your
sure,
back.
I more mean the information that isn't at black and white. So information where it's like, client has to agree to go to CAMH once a week, or client has to go to the drug and alcohol service, or that sort of I don't want to say softer data because I know it's still like special category
Yeah,
data,
I know
but
what you mean. Yeah,
the
yeah.
sort of more argumentative
So
action.
and so let's I think you'd only be able to do that. So let's say the example of like you've been told you've got to go to like drug and alcohol services. If you didn't have any drug and alcohol issues, then you could say you could probably use the data protection right to rectification on it. But if you do, then it's reasonable. They would see it being reasonable for them to kind of give that advice. And again, you'd have to challenge the reasonable step if you were seen to be uncooperative. Now, I can't see a situation where that should be a mandatory step. So you've got these kind of reasonable steps are separated out into steps the council will take, steps that you'll take, that as in homeless person. And then from that, there'll be mandatory steps, which are steps which have to be done, and then steps which are like recommended. And if I saw someone, if I saw a PHP which had like a mandatory step to go to drug and alcohol services, that would be a nonsense. But again, I'm like, are they really going to enforce it? Does it matter? I don't know. I just think that those documents are so worthless. It's not often. I don't know. As I say, you can kind of note it in an email, say this isn't right, or this is I'm basically I'm not happy with this, but I think more than that, I just don't think it's worth the effort. That'd be my opinion. But yeah, and I think you have got that. Yeah, I mean, you're right, Shannon. You've got those things could be pursued in other ways. So yeah. So next one, number 3. If someone is 46 years old, PHP says self-contained accommodations need with 1-bed rate, can one refuse a small studio and insist on a 1-bed flat? So I'm exposing my own ignorance here. I don't know that there's like a technical definition of a studio, because when someone says a studio to me, I'm thinking it's self-contained, but it's like, there'd be like one living room, so the kitchen, there'll be like a kitchenette on the side of the lounge, the bedroom and the lounge will all be the sort of same room, and there might be another toilet. That's what bedsit means to me. But I know some people, where it comes to bedsit, would probably mean sort of a shared accommodation. So you get your own bedroom, but everything else is shared. So the bathroom and kitchen is shared. I don't know if other people see that differently from me. Um, so in one sense, I would say what I would regard as a small studio would come under the ambit of a 1-bed flat. So it doesn't. I don't think when the LHA talks about like the 1-bed rate, it's not kind of specific to flats with a separate bedroom and a separate, I just don't think it works like that. But I mean, Shannon and Karis, you what's your understanding of the word bedsit? Let's just start with that. Is it similar to what I've just said, or is it something else?
Yeah, so bedsit, it's with shared amenities, a kitchen and shared bathroom, and your own bedroom is what you're entitled to. So studio flat and a 1-bedroom flat would kind of constitute the same thing. So what is the reason for refusing it? And should be very careful for refusing it, because this is where you could then be found to be the council discharging their duty, because that's not enough just saying you need that bedroom to be separate. Whereas a studio flat, because you don't share the kitchen and you have your own kitchen and bathroom, sorry, then that would constitute the 1 bed. So what's
Yeah.
your reason for refusing that tiny difference? And I don't think it would be enough.
Yeah, I think unless you had like a disability, you needed particular equipment, and you needed like a larger area or something like that, you might be able to change it that way. But I think, I don't think the UC would kind of see it differently. I think they see it as the same thing. And yeah, I think I'd just echo what Karis said. I don't know that what reason you could kind of give that would be enough to sort of say that a bedsit's not suitable.
You would end up, sorry, just because I'm a bit confused. So you would end up with, because there's for the LHA, there's a studio rate, isn't there? And then a 1-bed rate. So are you basically saying that even though they're entitled to the 1-bed rate, if they had a small studio, they would then be downgraded LHA rate wise to the small studio rate rather than the 1-bed rate, because it's basically the difference in type of accommodation is negligible?
So
I think that's a benefit. Yeah,
I've
question.
now I've confused. I'm just looking at the LHA stuff now. So they don't use the word bedsit. So bedsit is not on the LHA rates. It's a shared accommodation rate and then a 1-bedroom rate. Now my understanding is that a
Yeah,
bedsit would be it would be classed as 1-bedroom accommodation, even though it's not got a bedroom. It's just like it's a bit
yeah,
self-contained. Do you see what I say? But I mean, again,
yeah,
I don't know. I'm just going to see what definition. I'm just going to Google it now. Definition of bedsit, because as I say, it's a bit like the word hostel. It's a kind of a bit of an elastic term depending whereabouts you are in a country. I've just Googled it, and a 1-bedroom unit of accommodation typically consisting of combined bedroom and sitting room with cooking facilities. So but that still would say to me it's self-contained. So you get your own front door, and you have sole access to your little kitchen area, your bathroom, and your living area. So yeah, I'm hoping we haven't overcomplicated the answer to that question. I think that kind of, I think that made sense. Yeah, so yeah, your only reason you could kind of turn it down was if there was like a specific reason for it being too small or something, as in like you had as I say, a disability or something. Um, so yeah, if that didn't make sense, come back to us and we'll try and rephrase it. So we've got a multi-part next coming up, I think. Quite a long one. Hold on, getting there. Cool. Right. So yeah. What if a family including a 15-year-old with severe notable autism and ADHD They all have British citizenship and arrived in this country this year after fleeing a war-torn country. The mum's family home she grew up in 20 years ago was in southwest London, and all their family live in southwest London. The council now have placed them in a two-bedroom flat in Barking, which is almost a 2-hour commute back to southwest London for all their medical education services. As a family of 5 being placed in a two-bedroom flat in Barking, what steps would they need to take to get housed closer to their family, as well as getting a more suitably sized accommodation? So we might need a little bit of clarification on this question. So I think I understand it, but so my first question is the 2-bed flat they've been placed in temporary accommodation, or is it like an assured short hold tenancy or something? Because the answers that answer will kind of depend. I'm just looking at. I just need to kind of do a bit of geography briefly. So is Barking, is that sort of northeast London? So Barking, Dagenham. Okay, so yeah, so okay, so let's just break this down a little bit. 2-hour commute for medical needs. The council will argue that they need to transfer their GP to Barking and other bits and pieces. So most medical treatments that you get from the NHS will be available any area you're in. There's only kind of a certain types of specialist treatment which you can only get in certain areas. So I think that would probably be my first answer to it. In terms of education services, if we're talking about schools, then that gets a bit more, that's a bit different. So let me just try and work out which, I guess another question here is which councils actually place them. So if it's, I mean, yeah, so when it says the council, which council are we talking about? Are we talking about Barking Council that they've approached? Or are we talking about, I don't know, Richmond or Kingston or something they've approached? I think I probably need to know that as well. So yeah, so someone just come out and say, so it's confirmed it's temporary accommodation. Yeah, I don't know. So yeah, I think let's. Well, I'm going to wait. I'm going to wait to get that clarification actually before we go further, because otherwise I don't know what we can say at this point. Karis, have you got anything to say at this point on what we've got?
I would say the same as you. What council is housing her? Why is she housed in Barking? Because was she approaching Barking
Yeah,
Council to be housed in their borough?
yeah. Let's wait. Let's wait to hear that. We'll go to the next question, and we can always come back. So someone just kind of asked, so yeah, so basically the family connection. I mean, I guess just go back a step. The family connection could well count as being a local connection. There are some rather harsh judgments where extended family. There's one that really sticks in my mind. There was an Ipswich case where basically the person had been, they kind of left the Home Office accommodation in, I think, Southampton or Portsmouth or both. Well, I don't know how it worked, and they had like genuine kind of family, like cousins and stuff in Ipswich, but that was deemed to not be strong enough for local connection. So ultimately, they were housed in Portsmouth or Southampton, whichever one it was. So I guess the kind of in terms of what constitutes family connection, there's a video on the channel about it. So I think if you just search for the term family connection, then you're going to find that kind of a bit more detail about it. But basically, it does specify that it doesn't have to be immediate family. It could be aunts, uncles, grandparents, grandchildren, step parents, that sort of thing, as long as there's actually kind of a genuine relationship there. So we are in the ballpark of there being an argument, but that in itself is not going to be enough information to kind of give an answer there. So if we go to the next question. Okay, so again, so there's a question about benefits here. That's not what we're here to do tonight. So the next question I can see.
Want me to ask the last bit of the question? I can answer the overcrowded
Yeah,
bit.
go for it. Yeah.
Yeah, so you'll be allocated property per their allocation property, and there'll be overcrowding. So when you're talking about as well as getting more suitably sized accommodation, it'll be based on the ages and the sexes of the children. So one bedroom will suitably child if they're all 3 children are girls, all under 10, the ages of the children, so it'll go onto that. And if they're overcrowding, they treat a living room as could be converted into used as a bedroom, so you have other space that can be used as a bedroom. So overcrowding, suitably sized is what you're kind of referring here to. So the kids, and that will be all okay too. go in one room with mum and dad in the other room, and babies will sleep in with mum and dad until they're one. They're not entitled to their own room. So that's in
Yeah.
terms of the overcrowding bit and the suitability sized room. But if the child with severe ADHD and autism, she can have her own needs assessed. If she needs another room, you'll have to put that on assessment, occupational wise, and have medical evidence for that.
Yeah.
Uh,
So there's just clarification that it's the approach is to Westminster Council now. I guess this isn't probably very helpful, but I don't know why you would approach Westminster Council if your family are in South West London, because Westminster essentially, the best you're going to get is you're going to get a house in Westminster. Other than that, they're not really going to pay much attention. The way local connection works is, um, essentially, it would be far better to approach the council area that you want to be in rather than Westminster, because although they kind of take the stuff into account, it's a much more difficult argument to make than it would be if you approached your the council with where your family actually live. So although there is a kind of an argument to make potentially, it's much harder to make it this way. One of your options might be, and this again is quite convoluted, is to withdraw the application to Westminster and then apply to the council area that you actually want to be in. Now, again, that doesn't guarantee you're going to actually get housed there long term. It just depends on the kind of the family. I'm just kind of thinking aloud. Potentially, actually, your strongest connection to Southwest London would be the schooling, if that's what we're talking about here. So you might want to check the Westminster's policy on it, see if they've got like a kind of a school kind of policy. But I don't know. I might need to kind of think about this a little bit and come back to it to kind of answer it, because it's a bit. Yeah, I'm not quite. Yeah, in this situation, I think it's going to be quite difficult to challenge if it's Westminster that's got the duty, because I don't know. They're going to be limited in what they can do. So, and I don't know what you can do to kind of have a bit of leverage to kind of make the argument more strong. So I don't know. I need a bit more time to think about that. So I might come back to it. But so if we go to a couple more questions and circle back to this one in a little bit, if that's all right. I was going to hopefully kind of be able to multitask and ask those questions as well. So Ken, I think there's another clarification from someone else here that I think relates to this question, maybe, which is that the 15-year-old with severe autism and ADHD need the extended family's help, which would be that's a better argument to be making for sure. I guess again you're going to be relying on child assessments, basically autism assessment, any medical assessments that have taken place that evidence the fact there needs to be that kind of support network. So I think that's probably got a bit more traction than just certainly the medical stuff is probably not going to hold any water at all, because they're just going to say, well, you can get a GP, you can get whatever services you want to get in Barking that you could in whatever Kingston or wherever it is. So yeah, again, I'm hoping we're kind of getting the right end of the stick with that. The next question I can see here is you should have a period to question your PHP. Normally when it comes to pets, it's best to keep quiet, move them in and make sure they don't annoy or destroy anything. Yeah, I can't argue with that. If I was in that situation, I'd probably do that. I'm not quite sure we can say that, it's kind of like as a formal suggestion. In terms of like, with the PHP, you can basically always question it throughout. That's the kind of, as I say, it's kind of like this living document, this dynamic document. You can always kind of say stuff about it down the line. I don't know if there's that pets references about something specific, because I see someone's deleted a message. But yeah, so yeah, that's probably what I would do. I'd probably just kind of keep it quiet. I remember like a lot of TA, basically people are keeping their pets there, they're just not telling anyone, and they're kind of just keeping it under wraps. So if that works for them, then fair enough. So there's another question here about kind of benefits and stuff, effectively. So I'll put it in here. I think the answer from our point of view is going to be how long's a piece of string, but we'll see what we can do. So someone's moving into a one-bed flat. Good news. with the LHA, how much could they expect to contribute to rent and household bills if and when they start to work, if they were to start working either full-time or part-time. So it's going to really depend on exactly how much you're earning. But what I would say is I've seen actually, you know, for all the criticism that universal credit has got over the years, for people in work, even if it's just part-time, it's actually really, really good. Like there's a sweet spot of like, I don't know how many hours a week, like 16 hours a week or whatever, up to 30 hours a week, where you'll effectively get your living, your kind of your housing costs from universal credit, and you'll keep most of your wages. But in terms of the exact maths of it, you need to probably just go to Turn to Us or something to kind of do a calculation on it. So that's, but yeah, and yeah, again, it's not just about necessarily the actual amount you're earning. It might be like the hourly rate. It can depend on, because obviously if you're doing like 1 hour a week or something, you're getting paid £1,000 or something like that. It's a bit different. But yeah, Shannon, you got anything to add to that at all? I know this is kind of something you've done work with before.
I think, like you said, you want to use one of the sort of Turn to Us calculators, or benefit calculators out there. It's probably your best bet to work out what you might be likely to pay. Think of as private one bed. Again, check with the landlord which bills will be included within the rent and which won't be. Sometimes water's included part of the rent, often it's not. So in terms of the bill side of things, that's not normally affected if you start working, unless you've got like the universal credit package with Wi-Fi and BT and stuff like that. But yeah, everything you said, just check it out with one of the calculators or your work coach.
Yeah. So your work coach, I'd imagine, will be well happy that you're looking to get work. So they're probably gonna be super helpful and kind of give you the calculations. I think there's someone saying, I'm not some saying something didn't make sense about it, but I'm not quite sure if that's something we said or something someone else said. But I don't know. Let's hope it's kind of people are following it. Next question I can see is it okay if you're working whilst in temporary accommodation? So the technical answer is yes, but it makes things very complicated, because temporary accommodation is usually paid by housing benefit rather than universal credit. And so, whereas we've just said universal credit is actually quite good if you're in work, in fact, it's very good if you're in work, if you're claiming it. Housing benefit is a lot less necessary. It's not easy. It's more difficult to navigate, and ultimately, councils they probably, yeah, bottom line is they probably don't like the fact that people work in temporary accommodation, because it basically costs them more money. I won't explain why that is exactly. Now on the channel, let me see if I can find the name of it. I did a video about this not too long ago, which was like, do I have to pay for TA or something? So let's see if I can find it. Yeah, so if you search for a video on this channel called "Do I Have to Pay for Temporary Accommodation?", I talk about this thing in a bit more detail, well, quite a lot more detail there, because it gets more complicated. Because what you can find is if you're earning over a certain amount, then you'll get no housing benefit, and yet the cost of temporary accommodation is often astronomical. So it's just not actually workable for people who are in employment. There is some stuff that the council have to do. So the accommodation they offer you has to be affordable based on your income. So in effect, they would have to work with you, but we all kind of probably, well, I'm sure most people here tonight will know that councils are very unresponsive a lot of the time, and kind of very difficult to get a response out of at all. So kind of having to negotiate with that sort of situation and get the council to actually respond and kind of get them to give you advice is quite difficult. But check out that video anyway. So yeah, do I have to pay for temporary accommodation? Check that video out, because it goes into more detail on that. Yeah, so there's a kind of a follow-on part for that question actually. And will that have an effect on you getting a council property? No, it's probably actually going to go in your favour, I would say. If anything, it's certainly not going to be it's not going to be a deciding factor. So you may well still end up in private rented accommodation. I guess one thing on the positive side, housing associations like people in work, so they'll kind of probably more try and find a way of taking you basically. On the negative side is because you're probably going to have more spending power, it's going to probably mean that private rented accommodation is more affordable than it would be for someone who's entirely reliant on benefits. And what that means is you're more likely to end up in private accommodation. Again, I'm saying there's there's push and pull factors there. But it's certainly not a definitive kind of thing. It will just kind of depend on luck and potentially some local policies. Probably if you check your local housing allocation policy, if you just Google that term, whatever, like Bedford Borough Council housing allocation policy, and look for anything it does say about employment, because they got in trouble like initially when they sort of started doing this stuff because it was discriminatory against people who were disabled and therefore couldn't work. But since then they've kind of like got around that a little bit. But a lot of policies will have something which favors people in employment in some way, as far as they're legitimately able to do that. So just have a look at that basically. Right, have I just lost my place? Hold on, what's going on here? Yeah, I think we kind of covered that one already. So I think the next question I can see is this one here. Can a doctor help a person move from a rented property that's shared to a self-contained property if the person has PTSD? Pause. I don't know what pause is, and liver fibrosis that causes chronic fatigue. So yes, but it's very difficult. So it's technically possible. Effectively, what your argument would be is that whilst you have accommodation and you have a legal right to occupy, it's not reasonable to continue to occupy because of essentially the conditions plus the PTSD. So I'll give an example like of one situation. I mean, this is a high threshold. Most thresholds we talk about in housing law are relatively low or very low. This one's very high, I'd say. But I worked with a couple who lived in like a well-known antisocial behaviour hotspot in Bedford, like a block of flats, lots of drug dealing, lots of fights, lots of ASB going on. And the what we're able to do is essentially we're able to evidence with a psychiatrist report how over a period of time that that the lady had been accessing psychotherapy or psychiatry, whatever the word is, how she consistently reported that the things that were happening in the accommodation was making her mental health get much worse. So with that kind of armed with that, detailed evidence from the psychiatrist, we're able to make the argument that she was legally homeless and therefore she was able to make a homeless application and basically end up being housed somewhere else in a much better property effectively. But yeah, that you need that kind of level of detail. There may be some stuff within the housing allocation policy as well that would kind of get you onto the register with a relatively low banning. In some councils, that might be enough because there are kind of like medical needs, and it might come under the medical need, but it might not be enough to kind of class you as being legally homeless, and yet still be a little bit helpful. But I don't know, a GP, I would say, although technically could provide that level of evidence, it's unlikely you're going to get that level of detail because GPs seem to be not particularly helpful and forthcoming when it comes to providing medical evidence. But yeah, the answer is it's legally possible, but probably quite very difficult to actually get in the real world. Yeah, so and it's just someone saying there. So just I guess in fact I'll put it in there. No, yeah, I'll confuse it if I do that. So just I'm saying the documents need to describe the effect housing has on the condition, not just the condition. Yeah, so it's not the diagnosis in itself. You need to explore what it is about the features of this particular person's symptoms and essentially their particular accommodation, because it might be something else. It might be the fact that there's some really bad disrepair issues. There might be a really bad damp and mold or something, and actually the anxiety that comes with PTSD might be kind of being sort of set off by that. So there could be other things as well. So you kind of need to focus on the actual person's actual presentation, not just the diagnosis, and the actual accommodation, not just just generic accommodation. Karis, do you want to add something to that?
All right, just if this isn't obvious, just because they haven't said, but if it's moving from rented property and they should be talking to the housing officer, although they're asking for the doctor to help, the housing officer should be talking to your doctor and making those general inquiries if it's unsuitable. So they should all be talking together and working together. So if you're looking for the doctor just to write a report, talk to the housing officer as well.
Yeah.
Making sure they're making those inquiries that if this is unsuitable for you, why, and you put that in as well.
Yeah, I think a lot of housing officers literally won't know how to actually ask the right questions. So I would say in a situation like that, you'd probably have to like spoon feed the doctor with the thing they need to actually, the actual question they need to answer, and then take that back to housing. Because I've hardly ever seen a housing officer actually ask for anything more than just a patient summary, which would not be enough. The patient summary might confirm that the person has PTSD and liver fibrosis and whatever, but that in itself is not going to be enough. You need to show why the medical condition makes this particular type of, this particular accommodation unreasonable to continue to occupy. So someone's just saying, yeah, disagree with keeping pets under wraps. It'll come out, and then you could be thrown out if pets are not allowed. Yeah, it's a risk you're going to run, but I think given that some people literally will say, well, I'm definitely not going to part with my pet. I'd rather sleep rough. I guess they're not any worse off if they try and get through. I mean, I'd say I've known blocks of temporary accommodation where pretty much every other flat had a pet, and the kind of the landlord turned a blind eye to it. No one was that bothered by it really. So I think you have to weigh it up and kind of gauge it for each individual situation. But as I say, it's kind of a shot to nothing. You're not going to be worse off if your alternative is just staying to sleep rough on the streets. Yeah, there's a bit of a chat going on about that. Right, I don't know why we've got a Trump supporter in. We don't need to make America great again here. See you later. Cool. Cool. I'm just trying to find any questions going on there. It's a 6x6x3 enclosure. What sort of reptile are we talking about here? I'm interested. Okay. Yeah, okay. Right. Cool. Yeah, so that seems to have answered itself there, guys. So I think the next question we've got then, because there's no other questions in the live chat right now, is this one here, which is from the week, but it wasn't anonymized, so we're going to do it last. So someone's evicted for rent arrears a year ago, February 24. Arrears were actually been paid with the rent through Universal Credit. I was 2 months behind with non-dependent payments. Had a £500 drop in benefits, but still found intention homes because I paid phone contract and kids' clothing wasn't necessary because I couldn't pay the shortfall. Month after eviction, DLA awarded and backdated 4 months, which exempted me from non-dependent payment. Literally told to leave temporary accommodation on day 57. Told couldn't apply again, even though I had children, one disabled. Previous property 10 meters from busy main road. Okay, with CFT. Yeah, okay. So, okay. So I think let's try and work out how to tackle this. Oh, it's a green iguana. Nice. So I think there's two questions here. One is this person intentionally homeless? And second question would be, what do you actually do about this situation? Because the problem this person would presumably have is that the intentional homeless decision was from 2024, like a year ago at the moment. And typically you only have 21 days to challenge the decision from receiving the letter, not when they wrote it, but when you received it. That's important. So you've basically lost the review rights in this situation. However, and there was a recent case which was like in Hertfordshire somewhere, like Hatfield or I don't know, Hertford Town or whatever, where this kind of issue came up. Now I think that this change in circumstances in terms of the receipt of DLA would potentially be a new fact which is more than trivial. So you can make a fresh application to a council if something has changed which is more than trivial. So as in like, as in it is consequential, it makes a difference. And I think this award of DLA would make a difference. I'd argue as well potentially the original decision was wrong anyway. But with the fact that there's this DLA awarded which was then backdated, I think I'm just trying to think if this would be a direct relevance. So if we just go to the code of guidance briefly, where are we going? So if we go to 9.17, so search for it rather than messing around here. 9.17. So no, not 19.17, 9.17. Here we go. So for you to be intentionally homeless, there has to be a deliberate act or omission. And 9.17 states that generally an act or omission should not be considered deliberate where, for example, the act or omission was non-payment of rent or mortgage costs which arose from financial difficulties which should be on the applicant's control, or were the result of housing benefit or universal credit delays, or I guess by extension, DLA delays, I guess. So I would say, and I think this person can make a fresh application with this new information, basically get a new decision based on this new information. That would be my reading of it. But I've not had, as I said, I didn't read that recent judgment properly yet because it's quite quite intense. But what seemed to be the case was the new information that you could use to trigger a new application, but it was really, you know, it was hardly kind of, you know, it wasn't particularly substantial, let's use that word. So it was definitely kind of towards the trivial end of the scale, and yet it was enough to start a new application and get a fresh decision. So I think that that would be my answer. Let's get back to it. Sorry, get this thing back up. So yeah, I think in answer to your question, in this situation, I would make a fresh application. I would look on this channel and look for the video which says the best way to make a homeless application, and I'd basically follow the steps in that video, set out this information, kind of which covers all this stuff, and then basically, yeah, use that to get a new decision. And the decision, I think, may well be that you actually weren't intentionally homeless. I'm assuming here that the person is in priority needs. Now, in terms of the COPD thing, I think there is an argument to be made there along the same lines as the argument that you know, someone would be homeless because of damp and mold, because having really bad damp and mold in itself doesn't make you legally homeless, but it would do if it's causing respiratory issues. Now, I've not seen this argument advanced before, but I think logically you can make an argument to say, with, you know, backed up by medical evidence, I've got COPD, the street that this is, you know, highly polluted street, whatever. You know, here's the FOI, you know, here's the facts from the council that show it's the most polluted street. If you had a doctor which would basically say this person needs to be in an area which is not kind of the worst, you know, the worst air pollution in the area, then I think again that's another kind of strand that would show that the accommodation was not reasonable to continue to occupy. But again, I'm kind of like, I'm a little bit reluctant to sort of give too much certainty to that, because I've not done it myself before. Generally, like when I'm saying something, it's because I've kind of had that argument with the council before, and therefore I kind of have a better idea of it. But I think the other thing you say is, so it says here, whole family split up and council still reverting back to previous decision. If you've got, in fact, yes, so if you've got non-dependents, then they're adults. There is nothing stopping another adult in your family making a fresh application in their name. And effectively, the way that priority need works is, if someone in your family is in priority need with pregnancy or health issues, I'm going to go and just check this out for sure, because again, there's some really interesting caveats for this. But basically, the whole household would be in priority need. So let me just go back up to we're going a bit of a tangent right now, because this is where it gets a bit weird, yeah. So chapter 8 is all about priority needs. One of the strands of priority need is vulnerability. Let me just kind of set the scene a bit more actually first. So first of all, the automatic characteristics are, so pregnant women, dependent children in the household. Okay, you know, that's cut and dry. But we then got this idea of vulnerability. And so a person has a priority need for accommodation if they're vulnerable, and that's really kind of complicated, that bit, because of the following. So old age, mental illness, these two here, these would apply if, here we go. So yeah, so if in the case of A, B, and G only, so old age, mental illness, learning or physical disability, so we're talking about, yeah, someone with COPD, or G, any other special reason, you would have a priority need if someone in your household has one of those A, B, or G characteristics. Whereas if you had someone in your household who was vulnerable because of having, yeah, being a veteran, the whole household would not have vulnerability. This is really complicated, so I'm probably not doing a very good job here. But let's just kind of stick to the bits which do relate to this question. We're assuming here the person's vulnerable because of the COPD. If their adult child made an application in their name, they could definitely do that. There'll be no question of it. They could get a fresh decision. And the fact that, you know, the parent, I'm assuming here, has COPD and is in the family, so would potentially be vulnerable because of having a physical disability, then the whole household would be in priority need. Does that, Shannon and Karis, did that just make sense what I said? Because it's like, yeah, okay, I'm getting some nods. So yeah, that's hopefully that's kind of help the question. I think that might be the simple way of doing it. I would say you can actually make, yeah, the original applicant can make a fresh application based on the fact that there's this new information about the DLA, but it might be easier to get another household member to make the application in their name and have the whole argument again with the council, this time with the fact that, you know, that they were eligible for DLA, And that, again, that might kind of have an impact on it. The other thing that can happen in that situation is, so let's say you've got an adult child, they would not necessarily be intentionally homeless just because the parent didn't pay the rent, which again is what the council are trying to say here. So I think there's a number of kind of ways in which that would potentially would help someone out.
Can we just add on the reasonableness to occupy? I know you did address it, but I was going to say if there's no it's no test as such. It's just whether it's reasonable. So your argument would be whether it's reasonable with someone with COPD to live near a heavily trafficked area, and that would be all down to medical evidence and how bad your COPD is, and maybe a occupational therapist. But I think you did address it a bit.
Yeah. I think I'd say it's kind of like I'm using the same kind of like logic that you'd get from someone with damp and mold and was causing respiratory issues. So yeah. Shannon.
Yeah, I was gonna come in and say make an application with the adult children. I think just it might be helpful. Like one thing that the council would probably try and say in response to that is, well, you can make an application just for you. And so actually you've got a right to have that sort of private family life and right to live together. You can choose who you live with, just for seeing that as a potential issue. And then the other thing was, if for some weird reason that wasn't possible, my other workaround in my head was you could go to a neighbouring local authority, and then they would refer you back. Like, so if you were making this fresh application and the first local authority was still saying, no, you can't even do that, make it to a neighbouring local authority and then it will get referred back, at which point you'd be entitled to TA again. And I guess, I don't know if it's probably not worth throwing in around social services and stuff.
No, I think
but
it
they
is.
should never have been, just like if you were still found intentionally homeless, there is, social services would kick in and stuff, but hopefully we've given you like enough workarounds that wouldn't necessarily lead to that. But yeah, you shouldn't be left homeless as a family with dependent children.
Yeah, so I think there's not enough, we probably need to know like the full household makeup to know what else to say. But I think I'm hoping within what we've just said, there's plenty to kind of be getting on with. So the next question that's coming through the live chat is this one. Someone is offered exemption from LHA due to domestic violence and offered a one-bed rate under the local housing allowance. Can you only find and be offered a one-bed only in the council, the local council of the long-term occupation, or a one-bed in any council? So if you've made a homeless application to Council A, and they're going to owe you a house, let's say they owe you a housing duty, let's say you're under relief duty, and then you go and find accommodation like a private landlord in Council B's area. It's a one-bed flat. Yes, you're under 35, but you've got evidence from a relevant service that you have been subject to domestic abuse since your 16th birthday, and therefore you qualify for the exemption. Then Council A would normally be motivated to help you to basically pay that money and stick you in Council B's area. So that is possible, yes. But I think it would definitely hinge on the idea that you would have to find the landlord in the other area. And I did a video this week about kind of how much evidence you would need from for universal credit to get the exemption. I think I can't remember exactly. I think for DWP it said you need a letter from the police, or a MARIC, or any charity that's kind of had contact with you in regards to domestic abuse. So there is some evidence you need to provide. So it's not like just making a homeless application normally, where the evidential threshold is very low. Within the universal credit exemption, you need to have a kind of some sort of evidence from a relevant organisation. So what's the London Council with the shortest waiting list for one-bed houses? So for that, I don't know off the top of my head, but if you go onto the channel and look for the video called "How long do I?" Oh, let me get the exact title. So how long does it take to get a house or something? How long does it take to get a house? Yes. If you just search for that video, you've got the stats within the actual video itself. I put it in the video because I need people to actually watch the caveats with those stats. If I just gave you the Excel sheet, people would just kind of run away with it and just use it. They would kind of just not understand what the actual numbers mean. There are a lot of caveats with that. How you at, Cheeseface? Yeah. So yeah, just yeah. So interesting. So an adult child could make a fresh application with the parent listed as a co-occupier, and that would be a fresh application. Yeah, absolutely. Or where you've got a couple where, you know, if the husband was found intentionally homeless, the wife could make a homeless application, and there would be a fresh decision. There is this kind of idea of acquiescence. So I don't know if I've done a video about that yet, but basically acquiescence is the idea that where you've, in fact, yeah, I did do a video about this, but let me just reiterate the story very quickly. So there was a couple, their landlord was not fixing the fence, and the husband was getting really annoyed about this, saying, I'm not going to pay the landlord any money until they fix the fence. And the landlord duly evicted them because they had a contractual requirement to pay the rent. So the husband was found intentionally homeless. The wife then made an application in her name, and the council basically said was the evidence was that she knew that the husband was withholding the rent, and she didn't do anything about it. So she was said to have acquiesced in the husband's actions, and therefore she was also intentionally homeless. I think that's less likely in the case we've got here in terms of question 9, because I think actually, yeah, I just think there's enough in there that's much less likely to be an issue. But yeah, so it's absolutely possible to do it that way. So there's no such thing as an intentionally homeless family. That's not a thing within housing law. You only have intentionally homeless individuals. So multiple adults in the household can make applications. There's an exemption to that where, so let's say you've got like a 19-year-old adult child, but you've got dependent children in the household as well. The 19-year-old would not have an automatic priority need characteristics because the siblings are not dependent on them, they're just dependent on the parents. It's a bit of a weird one, but that's something that you probably need to look into if that's if that's the situation applying to anyone here. So yeah, that's it. That's all our questions, guys. Look at that, 8:31. Nice. We'll be back next week here. I think Will is doing his one on Monday evening, 7:30 on his channel. If you've not yet subscribed to Will's channel, do so. It's called William Flat Law channel, I think. I'll check that out as well. I'm pretty sure it is. But yeah, subscribe to that. You'll get notifications there as well. Other than that, I'm hoping tonight's been helpful, and I hope you can put some of that into action, and it's been interesting just because there are some interesting questions tonight. But other than that, keep going, and we'll see you on one of the videos on one of the live streams next week. Take it easy, guys.